further, the role of arbitral institutions today extends far beyond case administration. How do you see institutions contributing to broader conversations around ethics, procedural standards, and the future direction of arbitration?
Yeah, institutions are at the forefront, and I think ethics really is an issue in arbitration that we need to work together on. I like the idea of seeing whether there can be a bilateral or a multilateral arrangement, because ultimately institutions are not bar regulators. But LCIA took a very important first step by having the annex on counsel conduct, so that there can be some codified powers to tribunal to be able to regulate the conduct of counsel in an arbitration. We're in the midst of the rules revision process, so it'll be interesting to see how the LCIA is able to take that additional step. I often quote the term that is given to counsel conduct, that it is effectively like the messy bedroom of a teenager, because you have all of these different jurisdictions with different standards being applied, and how do you regulate this? I think it's also important for institutions to be introducing cost discipline and procedural discipline. So some of the most important procedural tools that we've seen in arbitration, and it's very interesting to examine the evolution of emergency arbitration, early dismissal, expedited procedure, consolidation, and joinder. These are all tools designed to really deliver on that promise of arbitration, that it is going to be fast, cost-effective, and efficient. So when you see some of those most important procedural innovations and really some of the broader innovations from arbitration, these tend to emanate from the institutions. And LCIA is in a fairly special place because of its history, that really, I think the arbitration ecosystem is looking to LCIA and its history of thought leadership to be the standard setter, to be making the difficult decisions that make arbitration better.
You also spoke of some sort of discipline regarding cost. That's something I'm sure everyone will be very keen to hear about. How could an institution play a role in that?
Well, we get a lot of benefit from the ICC Commission report on costs, and this, when I'm promoting institutional arbitration, I will often be saying, with apologies to all of my friends and colleagues in private practice, that about 80% of the overall costs in an arbitration are the legal costs. So I will often be meeting with in-house counsel, and they will be putting the cost schedule of an institution side by side and saying, well, this one is cheaper, so I'm going to choose this institution than this other institution that perhaps is a bit more expensive on paper. But the ultimate driver of the overall cost of an arbitration is duration. So if you have an institution like the LCIA that is able to administer disputes expeditiously and avoid unbargained for delay, it is always going to be more cost effective to go to an experienced institution. And there's a real question in arbitration about the remuneration of tribunals, of whether or not the hourly system, like we have at the LCIA, or the ad valorem system, where it is fixed fee caps based on the maximum sum of dispute. Now, I think this is often horses for courses. I don't know if we're able to get to an answer on which is better. But importantly, and I would encourage everyone to look at the LCIA cost and duration report, because it found, at least in this study, that LCIA was the most cost-effective of the major institutions at every amount in dispute, except for under $1 million USD. But you can see, as disputes get higher value, that the LCIA cost advantage starts to increase. So we want to see if we can, in addition to having that gold standard case management that I think really helps, but is there anything else that we should be doing? I often point to the ability for tribunals to set page limits under the LCIA rules. This is important. I look at language in the LCIA rules that give tribunals the widest discretion. I think that's important, because ultimately, if users are choosing arbitration because it's cost effective, we have to deliver on that promise and the bargain. Their expectation is that this is going to be fast and cost effective. And I think about 10 or 15 years ago, I think that arbitration was losing its way to a certain degree, that it was starting to take a long time, starting to get very expensive. And I think that LCIA and all these institutions have really focused on making sure that it is cost effective. And when I'm looking at the institutional landscape, I don't really view the institutions as being in competition. I view myself as a promoter of institutional arbitration. Right. And that is what we really have to focus on and make sure that we're delivering on the promise for why arbitration users choose arbitration to begin with.
I think your core philosophy there of promoting efficiency, better case management, I think that is the way for costs to sort of remain under control and remain in the arbitration system cost effective.
And one underrated element of cost that we don't talk about enough is that there is the transnational tradition in arbitration that the losing party will bear the successful party's costs.
Right.
And this can matter when you're getting into costs that sometimes can be in the very large disputes. It might be 8 or 9 figures on each side in terms of the cost. But if you're in certain jurisdictions in court, no matter how successful you are, each side is going to bear its own costs. So the idea that you can get this fast and cost-effective mechanism, and if I'm successful, if my claim is good, that I can get all of my costs back, that is a very attractive feature of arbitration. Some of the international commercial courts are starting to trend in that direction, and that's why the institutional cooperation is so important for me, because we are not competing against each other, we are competing against other forms of ADR. Is arbitration relevant and credible in 2026 as opposed to mediation, adjudication, dispute boards, structured negotiation? Is it still fit for purpose?
And this brings us to something which is probably something you're thinking a great deal about, and which is something we need to consider how much we can employ this tool, and that is artificial intelligence, is beginning to reshape legal practice globally, from document review to drafting and case strategy. How should arbitral institutions approach the opportunities and risks associated with AI in arbitration?
I guess with AI is that it's already here. This is not something that we're sort of looking down the road as a problem that we will one day need to solve. We have to deal with it right now because it is already being used in arbitrations by counsel, experts, and tribunals. So for right now, I mean, this is often, if nothing is being said in an arbitration, or it's being dealt with in the first procedural order. And I think what is important for me is establishing the necessary guardrails on the use of AI. Obviously, the sanctity of the data is critically important, the same way that you wouldn't want an arbitrator putting case information into a search engine is the same reason why we have to be careful about how that information is being put into an AI tool. And I actually think that the construction of the LCIA rules could actually work quite well for AI. So the annex on counsel conduct that LCIA already has embedded in its existing rules, I can see a space where there would be a similar annex on the use of AI. And the challenge for AI is because it is moving so quickly, how could you ever hardwire it into the rules? By the time you went through the rules revision consultation, it would effectively be obsolete. The other challenge is that if you have it by way of guidance or soft law, it doesn't have the necessary teeth that it may have if you had it in the rules. So I think that what I envision is that the LCIA may have an annex on AI, and this annex would be updated and then have prospective application, and that's how you could make the regulation remain current.
Do you have such an annex in the works, something you're grappling with at the moment?
So if you look, it almost is like you're looking at the LCIA laboratory. If you look at my desk or my home office, I have many different drafts of an annex, and this is something where we're getting community feedback on what the community thinks that we should be doing with AI. And having drafted 4 sets of rules at SIC and now on my 5th set of rules, I think one thing that I've gotten very good at is listening. So there are certain features that I think would be to the benefit of arbitration, but ultimately it doesn't matter what I think. We don't want to be ivory tower. It's what the users tell us. This is what we want LCIA to be doing on AI. So we've already received a lot of feedback. We'll be coming out with the first draft of the LCIA rules. I guess maybe it'll be ultimately 2027 rules, but sometime probably in Q3 we'll have that first draft, and then we'll have another round of feedback from the community and further update and refine, and then hope to go to publication sometime in 2027.
I'm sure the arbitration community is looking forward to that, because LCI always leads here, and I think that will provide a sort of good standard by which others can also probably emulate and see how that goes.
Well, it's always an advantage to be the most recent iteration of the rules, because that will be the most modern, and I can see how some of these procedural innovations have been emulated. And so I think now some of the provisions I introduced in the SIC rules 2025, ex parte orders, streamlined procedure. You now see these mechanisms being considered by other institutions. So when a major institution really starts or moves a first innovation, then you see the way that it can be embraced by the larger arbitration community.
And this brings us to something which was being discussed in a number of the discussions yesterday, was how does arbitration law develop when awards are confidential? So how can the concerns of confidentiality be balanced with transparency? And more importantly, the role that published awards can play in enhancing the consistency, predictability and credibility of the arbitral process. I know LCIA allows for confidential awards, but is there a way to anonymize and publish in such a way that the law develops and there is more consistency? Is there something you see here?
This is an issue that I've wrestled with for a long time, and we saw it during some of the presentations in Cyprus. So arbitral precedent, you could be, a tribunal could be relying on arbitral precedent based on one case, and that maybe it's persuasive authority, but there could be 100 other cases that decide in a different direction that are not published. So how do we develop the arbitral jurisprudence? And I see this in with early determination, summary procedure, early dismissal, nomenclature is slightly different, but the same mechanism, because we're still relying on jurisprudence from investment arbitration, trying to apply that in commercial arbitration. So borrowing from my betters, I did not come up with this, but I do like to use the exercise of, if we didn't call it confidential and we called it secret, how much different does it feel? Because now secret, instead of confidentiality being perhaps a virtue of arbitration, now it seems a bit shadowy and mysterious, and it doesn't sound quite as good. I think the difficulty is that everyone wants transparency on someone else's case. So if it's my case, if it's my client, no, I don't. I want confidentiality, and that's one of the reasons that users choose LCIA, because unlike some institutions, you don't have to opt into the confidentiality. The confidentiality is already right there. But for us as arbitration practitioners for this arbitration ecosystem, how do we keep credibility without having some transparency? So what I've tried to develop at LCIA, and what LCIA had already been doing, I think, is balanced transparency. How can we improve arbitration scholarship while maintaining the confidentiality of proceedings? So I think the LCIA database of anonymized decisions on challenges to arbitrators, I think this is a great resource. I often say to counsel that this is a resource that they can draw upon in other institutional cases. So this is not only relevant to LCIA cases. There's a lot of important points on how we're looking at independence and impartiality relationship in arbitration chambers, or say issues if you have related cases and you have one common co-arbitrator. Will that go to independence and impartiality? Is that arbitrator able to compartmentalize his or her mind on one case from the other case? So what I'd like to see is, I would like to see LCIA and other institutions, and I think Hong Kong has done this and done it quite well, say publishing some of the reasoning on early determination. I think this would be helpful. I mentioned at the conference also, say on consolidation, the compatibility of arbitration agreements. Can an arbitration clauses with a different seat, are those compatible? What about different governing laws? I think this is information that helps move arbitration forward, and I don't think it's always the publication of a merits award that is going to help arbitration. And you think about the sort of sacrosanct nature of the information that an institution holds. We have arbitrations involving states, state secrets, we have chain of custody procedures, some of the most influential corporations in the world that are relying on this confidentiality. So how can we take this and get to a bit more transparency to help the credibility of arbitration, especially as measured against other forms of dispute resolution? It's a complicated issue. I don't have a perfect answer, and sometimes I think my view on it changes day by day.
Will you have something in the new rules on this? Some modification to push it in, especially the sort of things you just said, where it's not really the merits of the award that's being published, but more sort of procedural aspects, which are more likely to be helpful. Is that something you're still grappling with?
I think it's something that I personally would like to see in the rules, but let's see what the crowdsourcing says, and let's see what the community says. But I can see language to the effect that LCIA is able to publish anonymized versions of certain procedural decisions. Maybe not merits awards, because the problem is if you make it opt-in, it is very unlikely the parties are going to agree. And it also depends on when do you ask the parties. Do you ask them at the commencement of the arbitration before the award is rendered, or if you're in a model law jurisdiction, do you ask them 91 days after? So after the 3-month opportunity to potentially set aside an award. But usually once the arbitration is done, parties are not interested in publication. So I think that it is something that needs to be put in the rules, and then the parties can opt out. But let's see how that dialogue goes.
Requires some sort of collaboration amongst the key institutions, otherwise they just jump one institution to another. If there's some sort of consensus on this, so that they can't really institution shop on this issue, if at least the key institutions have some sort of because that would be the reason why an institution would be reluctant to push on this.
Well, that's an interesting question is whether do we want convergence or divergence? Right. So do we want all of the institutions to be pretty much the same, or do we want there to be a bit of a menu of different dispute resolution options, say where one institution publishes awards, and then say for a certain transaction, maybe parties think, okay, we want LCIA for this transaction because they have robust provisions on confidentiality, and for this deal, confidentiality is important to us. And maybe for this other transaction that we have, we're happy for the anonymized publication. We trust this institution to publish things in the right way, and then we're fine to go for that institution. And so that one I wrestle with as well, of whether institutions should start appearing more the same, or there should be comparative advantages for each institution. I think this is particularly relevant for disputes arising from different sectors. So in my letter announcing the consultation process on the LCIA rules, I highlighted or at least sort of mooted the possibility of having sector-specific plugins, so that where you would have an annex similar to what I did with arbitration mediation, arbitration protocol in Singapore, the insolvency and restructuring protocol. Do we need to have some additional regulations rather than having different sets of rules? And so I think this is something that's important as well. But the convergence and divergence question is a tough one. But one thing I would say, where I would like to see more institutional convergence is with the publication of statistics. This is something that we have been trying to get done in IFCI. I know the heads of some other institutions that I very much admire. We are au fait and very aligned on trying to have a common language for statistics, because if you think of the lay arbitration user that does not understand the institutional framework, institutions are counting cases differently. Some if there's related cases, they would count it as 5, others would count as 1. And I think to give real institutional choice and to avoid sort of an asymmetry in the market where it's not just the arbitration intelligentsia that knows the difference of the institutions, we have to be able to put it out there to the new institutions, and we shouldn't run away from these statistics. Statistics are not a way of measuring how good you are as an institution. There are any number of variables that will affect how many cases that you have in any given year. We're doing a study and looking at around 2,000 LCIA cases to try to assess the performance of party-nominated arbitrators versus institutionally appointed arbitrators. So is there a difference in efficiency? Are there fewer or more challenges to arbitrators? Are there fewer or more minority opinions? And what I said to all of my staff at LCIA is that if we're able to get this done, we publish no matter what the data ends up showing. And you don't just publish statistics that are good for you as an institution. You publish it to better inform the market. And overall, what I really see in arbitration is a move towards quality. I don't think that users are shopping based on the number of cases. They are shopping based on the user experience. So it's more quality, I think less in the way of hypermarketing and tricks and toys. It is a trend towards quality, and I think that institutions should be very comfortable showing their statistics and really be marketing their quality, not the number of cases.
I'm very happy to hear that. This really sounds like something that will bring a profound change in how users can access different institutions. And yes, then the standard does become what you're really going to get in terms of quality.
Yeah, and one of the things that we're doing alongside this is that we are trying to build the best cost calculator in arbitration. So this is alongside some of the work that we're doing on AI tools. And this is actually not specifically AI related, because I was always frustrated, and I think users would be frustrated when they would go to an institutional website and they would put in the amount of their dispute, and they would get relatively vague figures of what the minimum fees or the average fee or the maximum fees, but really you could do the same with a handheld calculator. You could just go to the schedule of fees. So what we're trying to do is have a cost calculator where there are a variety of inputs on the nature of your dispute, sector, industry, number of arbitrators, potentially even the complexity, and then you could get an indicative or measure of the costs that are based on actual cases. So the way that the output would be, it would say, based on 73, for example, LCIA cases, the average cost for this kind of fee, for the institutional fees and the tribunal fees, would be this amount. So it's based on actual data, rather than just based on, say, maximum costs in the schedule of fees. Because if you have, say, a very complex construction dispute and a simple debt claim, these are going to have very different costs, even if it's maximum fees and even if the quantum is the same, just because the amount of work that needs to be put into that arbitration is going to be quite different.
We'll end on a personal note. So what is your key takeaway from Cyprus Arbitration Day on a personal level?
Well, first of all, I don't know if I've ever been to a jurisdiction where people are more friendly. I don't know if you've had the same...
Certainly, it's been an exhilarating, wonderful experience. I hardly knew anyone when I came in, and there's so many friends that I'm going back with.
Yeah, and you really feel like that there are proper friendships that have been forged here. I mean, this is my first time in Cyprus, and I always get quite energized when I go to a new arbitration jurisdiction, and I see the potential of Cyprus. And I think there are some analogies that can be drawn from my time in Singapore and my time in London. You can see where Cyprus sits in the world, so where you have geographic and cultural connections with Europe, Middle East, North Africa, that this could be a place where people really come for arbitration. You've got a common law system as well, good courts, good legislation. So when I come to places like this, I really do get energized for the future, and many of the same things that I've been saying about India, because arbitration is not going to be London, Paris, Geneva, Singapore, Hong Kong, New York, and these sort of main seats of arbitration. Arbitration going forward is going to involve Cyprus. It's going to involve India. So it has been an outstanding experience. I think that I've already promised to be back next year, and I think we're talking about maybe getting even a bit more LCIA involvement in Cyprus, because we've had, I think it's 200 cases from Cyprus in the last 10 years, and of course you have a lot of holding companies are being set here, and so if you look at some of those economic indicators, Cyprus is a pretty good place for arbitration, and based on the morning walk that we went on, I think it's a pretty nice place to have a hearing.
Absolutely, yes. So thank you so much for taking the time out and sharing your views. I'm sure that not only our viewers, but people listening from other institutions will be inspired by your ideas and take the cause of arbitration forward and strengthen institutional arbitration. Thank you so much.
Thank you.